7 or 8 months after a late charge, you decide to unilaterally close someone's account.
No, Your Honor, I closed out this account because he was spending money on it like crazy. It's our joint account.
The request is going to be granted. You're in contempt, ma'am, and I don't know how you don't see that. You just completely closed someone's account.
It was
no reason whatsoever. I'm also going to require that $5,000 be transferred back. I'm not going to impose any civil fees. The $5,000 needs to be. I'm talking, ma'am.
Okay, I'm sorry.
Talk for a very long time.
I apologize. Her haircuts. We have been going to the same hairstylist for years and years. She knows our daughter's hair. She has difficult hair, and the hairstylist knows it. And that's why I asked who cut our daughter's hair, because I was curious to find out why they didn't take her to the regular hairstylist that we normally go to. These are not frivolous questions. These are just questions that I'm asking Mr. McGill. It's not like I ask him a question every single day. I ask a question maybe once or twice a month, things that I'm not aware of. The last one with the illness, she was sick for 3 days. I had no idea. It's not the fact that she doesn't go to the doctor. I don't need to really know that portion of it because that's Lexi's private, but I think I deserve to know when she's sick. With the school, she's saying I'm sniping. There's no sniping here. If you read the text messages that I gave as an exhibit, you'll see that there's no sniping. They're regular questions. They're just honest, simple little questions that he could answer. And that's why I'm asking for the family app. Hopefully there can be some sort of communication between us because evidently there's none at all. The only thing that is available to me online on the school site is whether what sports are being played. I have no idea what sports Lexi is in. And the only reason I found out about the one sport was I got online on the school site, like Mr. McGill asked me to the last communication that we had. And that's when I saw that she had done wrestling. So he's not giving me her extracurricular activities so that I can at least be in the know for her. And it's just really sad that he doesn't want to do that. But the fact is, Your Honor, these are not frivolous, and he did commit contempt of court for them. And the rules are the rules. He should be held accountable, because if he doesn't, it's never going to stop. He'll just keep thumbing his nose up at this court order. So I asked the court to give me the relief that I asked in my motion for contempt hearing. Thank you. I've just recently found out that my daughter has taken driver's ed, no knowledge of it to me whatsoever. That is stipulated in the parenting plan under joint decision making. I only found out because I needed insurance papers, and I saw that her name was included on the insurance forms. That was something that I should not have missed. I should at least been informed, and he just refuses to do that. And I don't believe that he is going to continue to give me the information that is required that the court has said I am entitled to. And that's evident by him sending in a proposed order that he wants to change the parenting plan again. The joint decision making, he wants to be sole person who makes all those decisions, and that's just not fair. I just recently found out, and just because he told me that I need to go on the school site and look for my daughter's school sports, that she recently was in wrestling, and I had no idea of that either. And he's just not.
I would object to any information that's outside the scope of the declaration.
All right, that's noted. I'll let you continue. I'll only consider what has been before the court by declaration, but go ahead.
Okay. Unfortunately, me being pro se, I can't ask for fees to cover my time and my expenses. I asked the court for a civil penalty of at least $500 for Sean, the same amount he requested for attorney fees. I believe that that's only fair. I also would like for him to take a parenting class. He obviously doesn't know how to co-parent.
She is being completely ignored by her own 16-year-old daughter, and it's the father who has to take a parenting class? I don't think so. She's mad because the guy is being a great dad. Let's keep going.
I also request that he provide the family app our family wizard and that he pays my portion of that.
What the?
Maybe we can have some sort of communication that way. I don't know if that will work either. But those are the things that I'm trying to request. And another thing, I was really shocked that my daughter, or our daughter, is no longer in counseling, and that was ordered by the Judge Scudder. That was just plain shocking, and she definitely needs counseling. And I believe Mr. McGill would agree to that. This started when Lexi was 13, so there's been a year and a half. She'll be 16 in April. And I just don't want her to come back to me one day and say, Mom, how come you didn't stand up for me? How come you didn't try to protect me? Why didn't you fight for me? And that's what I'm trying to do now. I'm just trying to have information on our daughter. I don't even have pictures of school sporting events because I was never notified that that's what she was doing. And that's a shame. It really is. I think that the petitioner has definitely talked about the divorce to our daughter, just by the things that he is saying.
I'd just object as to speculation.
I put that in my declaration.
All right, it's noted.
This is the plain facts. There's no getting around it. Sean McGill has violated the court-ordered parenting plan and should be sanctioned. And I given the relief that I requested in my motion for contempt of hearing. There's just no way around it. He has committed contempt. Thank you, Your Honor.
Thank you.
She is basically trying to screw him over in every possible way and assuming all sorts of things she made up in her head. Meanwhile, our hero remains unfazed, not giving her the attention she so desperately craves. That earns my respect.
As far as housekeeping, Ms. McGill did attach to her initial declaration at page 7 a copy of the insurance binder. We are asking that that be removed from the public file because there are identifiers, private identifiers that are affiliated with that document. It needs to be filed under seal. So we would ask that that be removed from the public filing and placed in the sealed filing. Second, as I noted at the top of this argument, my client has not been personally served, obviously, which is a requirement under the statute. My client, at least in his declaration, has asked that you consider striking this. Obviously, we are hearing this at this juncture. And ultimately, we're asking that the court find that Sean McGill has not willfully violated a court order. We're asking you to deny Ms. McGill's contempt request and award my client $500 in attorney's fees for having to respond to this. Clearly, when the court reviews through the parenting plan in light of the allegations by Ms. McGill, there are some conflicting provisions within this parenting plan as it relates to paragraph 14A about my client having the ability to make decisions on activities during his time compared with the joint decision making and as well as in 14B. There's also conflicting provisions there. First off, my client is not obligated to provide documentation that is available to Ms. McGill through her own efforts. And clearly she's not made those efforts. Even in her argument, she acknowledges that she just now is finding out information, I'm assuming through Skyward, which has been available and accessible to her since her daughter's been in school in Kelso. So addressing each of the issues, and I would note that the majority of these issues, quite frankly, should, if anything, be time barred. They are so old that clearly if there was an allegation that should have been raised in a timely manner, and she has not done so. Her claim number 2 is a claim from nearly a year ago. My client tells you that Lexi signs herself up for various programs within the school district. If there is a fee, she lets him know and he provides that payment. And again, that's information that's available through the school sites. My client is not obligated to provide her with pictures. My client is not obligated to take pictures on the first day of school and provide those to Ms. McGill. Those are completely frivolous requests and not contemptible action on my client's part. Number 3, she says my client, on number 3, my position is that my client should not be found in contempt, again, for failing to provide a picture of Lexi on the first day of school. There's nothing, as I indicated, that requires him to do that. And as you can see, not only through my client's declaration, but through the guardian ad litem report, Lexi wants absolutely nothing to do with her mother. She does not want
Objection, Your Honor.
What's your objection?
Well, first of all, this is a report about contempt, not about what the guardian ad litem had to say. This is he violated these orders that were ordered by the court, not what the guardian ad litem to say. The guardian ad litem is not the judge.
Stop it. Get some help.
A few moments later.
Lexi is learning her own life skills. She's learning how to manage her money. She is going to have automobile expenses or automobile insurance expenses and the like. And this is all part of her learning process. She should be entitled to have the use of her own funds. Those, as my client tells you, were primarily birthday gifts from himself, birthday gifts from third parties, monies that she's earned and the like. So we're asking that the court order the immediate return of the $5,000. At this juncture, we have no idea where those monies are held or if, in fact, they've been fully deposited. We've provided with my client's initial declaration the documentation that would be necessary for Ms. McGill to sign to remove herself from Lexi's account. We think that that's important because clearly we think that she's going to take this type of action in the future. It is concerning that she provided absolutely no notice, no correspondence stating her concerns about my client's supposed actions to remove monies, which again are totally unfounded. And then we have that coupled with the issue where my client has had his USAA visa for years. And currently, or at the time, that visa interest rate was 14.65%. He had also accumulated benefits under that account, or rewards as it were. Again, without absolutely any notice to my client, he goes to use the credit card and is denied. And come to find out, Ms. McGill unilaterally closed out the USAA visa, again with no notice. And my client lost his long-term credit card. He lost that lower interest rate. And obviously, we've seen interest rates skyrocket in the current financial circumstances of our country. And he also lost those reward points. So again, we're very concerned by her behavior. And we, to be quite honest, I don't know, you can't recover his interest rate. You can't order the credit card company to reinstate him. You can't reinstate his lost rewards. So those are lost to him and to the community in violation of the court order. And coupled with that, you have a credit card that had a balance on it that has been closed out, which provides a negative impact on my client's credit report because of the closing of an account with a balance on it. So we're asking that the court enter a finding of contempt. We want the $5,000 returned back to Lexi's Navy Federal Credit Union account. The order provides that those are to be returned no later than July 10. We're asking, although at the time when I prepared my proposed order, I don't believe that your docket, and I think now your docket on the 11th is closed. Oh, maybe it's not. So we are asking that you set a review for July 11th at 1 o'clock to review and determine if she's complied with depositing those monies, if she's signed and delivered the documentation to remove her name from Lexi's account. We're asking that the court award my client attorney's fees and sanctions at $200 and attorney's fees at $1,800, and that she comply with the orders in the future.
All right, thank you.
Did you notice that she's only trying to screw him over to gain some financial advantage? She takes her own daughter's money, tries to use the credit card of the ex-husband she constantly criticizes. It's pure hypocrisy.
You're goddamn right.
That savings account was a college account. It was not a personal account for Lexi. We, as responsible adults and parents, opened this account when Lexi was 1.5 years old. We put her name on this account in case of our death, and it would be easier for her to have the account. The money that was deposited in that account was through our community monies. We also deposited in the money that we received from COVID. There were checks from my sister and from friends that were deposited in that account. And I've opened a custodial account to have the $5,000 deposited in. I have not deposited in that account yet because I know that Mr. McGill would accuse me of hiding the money. It is in my savings account, as I stated in my proposed order. Mr. McGill will spend that money with his desperation, as evident by his actions regarding our joint credit card. Mr. McGill intentionally made frivolous purchases and also added $3,000 of his attorney fees to our credit card. I mean, that's common sense. You don't do that sort of thing. He just wanted a reaction from me, and he got it. I had no choice but to close out the account. If he would have been paying $200 as ordered by the court, it would have been paid off, and then we wouldn't be here today. Mr. McGill's maintenance. So after that was closed, I couldn't take my name off of that account because there was a balance. And if he would have paid it, then there would not have been a balance left on that account. Mr. McGill saying he didn't know he had to pay $200 a month is just plain laughable, Your Honor. His attorney should have gone over that court order with him to explain what it was that he needed to do. He didn't pay it. There were months that he didn't pay anything at all, and then he got a $25 fee for that. It affected my credit score also. I had no choice because I didn't know what he was going to do. Our credit balance, our credit was $16,500. He was going crazy spending money out of that account. And I was afraid of what he was going to do with the college fund for our daughter. So it matters in my own hands. And I did that because I'm protecting that money for our daughter's college fund. He had no reason to be spending on that credit card. It was our joint credit card. He has his own credit cards that he could have done that with, and he didn't. So I'm not understanding what the whole situation is here and why he's crying foul when he's the one that did this to himself. It doesn't make any sense to me whatsoever. Those monies that were taken out were at the ATMs. For them to say that that was all used in gambling is just crazy. Let me get this here real quick. Yeah. The money's taken out of the ATMs. At the casino on Mondays, they have Senior Citizen Day, and they give us all seniors a free gift. And while I'm there, I use the ATM. My bank is in Olympia or in Lacey, Washington. So I just take money out for spending money, for my entertainment, for gas, to pay my rent. I've been paying stuff cash here lately because I feel like Mr. McGill's always tried to control me, and this is my way of not knowing my money is being spent at. It's just my way of getting my self-control back. So I'm not understanding any of this stuff. So that's why I want the court to order him to pay the $7,000 on the credit card. He put $5,000 within 2 months on that credit card. $3,000 of it was for his attorney. He spent $552 at Walmart.com, $43 at Walmart, $156 at Walmart, $245 at Depot. He spent $767 on service and parts. It's like he brought this on himself. And then another $430 on beekeeping supplies. I mean, it makes no sense. It was frivolous purchases from the very beginning. And that's about all I have to say on that, except for them to put all those ATM things under gambling is just ludicrous. Thank you, Your Honor.
All right, thank you. I guess I'm a little bit concerned. I don't see anywhere, and maybe someone can point it out to me. But my understanding was that Mr. McGill was allowed to use this joint credit card In the financial documents that were filed, and I've looked through the documents filed by Miss McGill and the documents filed by Miss McLean. To be very frank, Miss McGill, attorney's fees on credit cards are something I see every week. That's not weird. If he was making payments on it and that was his account, even though your name's on it, I don't, and I'm going through what you filed. And if you could point out what page there's a late fee, I'd like to see it. I don't.
Oh, you mean on the credit card fee? On the Visa?
Correct.
She did all of this out of malice, and her karma was instant. The judge understood that our hero was not wrong in how he was using the card and that her arguments made no sense. In the end, the truth always prevails. Let's keep going.
7 or 8 months after a late charge, you decide to unilaterally close someone's account.
No, Your Honor, I closed out this account because he was spending money on it like crazy. It's our joint account.
I mean, the request is going to be granted. You're in contempt, ma'am, and I don't know how you don't see that. You just completely closed someone's account.
It was
For no
all my
reason whatsoever.
too.
I understand that, but
Okay.
I see that he has use of that account. He's paying on that account. If there's a late fee from October, I'm sure he's taken. I don't care what. Maybe at trial, it's going to matter what everybody's spending their money on. But frankly, you hurt yourself by closing that account because now the interest rates are more of his money is going somewhere else and potentially not to your daughter or to you based on whatever the outcome of this case is going to be. So I'm going to make a finding of contempt. I'm also going to require that $5,000 be transferred back. Frankly, looking at both of your accounts, if you have the money to spend, I don't know that frivolous things, if he wants to keep these or if he wants to repair a car, I don't have a problem with that as long as he's paying for it.
Right, but Your
It's
Honor,
not hurting anyone else.
I
I don't care if you go to Mr. Bill's for $500 a month, if that's what you want to do. I don't care.
I understand.
But that $5,000 is going to go back to Lexi McGill's account and in its entirety. I'm not going to order a civil penalty at this phase. I am very concerned, Ms. McGill, though. This to me is, I know you feel the exact opposite, but this to me is a very blatant and direct violation of the court's orders to just unilaterally close an account, very much to the detriment of the petitioner in this case. So I am going to make a finding of contempt. I'm not going to impose any civil fees. The $5,000 needs to be. I'm talking, ma'am.
Okay, I'm sorry.
To talk for a very long time.
I apologize.
So I'm not going to impose a civil penalty. I am going to impose the lawyer's costs and then the transfer of the money. I am not here on the 11th. I think we do have space on the 11th to do a review to just ensure that that was taken care of. So we'll set it for the 11th.
Your Honor, I'm out of town on the airplane. I'm out of town on that day.
If you've done what you need to do, then it's okay if you're not here. So as long as everything is that money, really it's just a review to make sure the money was transferred back into her account.
Is the court also ordering that she sign the release to remove her name from Lexi's account? That's at paragraph 11B.
Why don't you just close that account out?
Clearly, you're not concerned about the benefits of some of the accounts with Navy Federal Credit Union and USAA. So I don't want to just close that account. I am signing the order as proposed, apart from the civil penalty.
The judge simply lost patience with her. This happens when you're clearly just trying to hurt someone who is genuinely dedicated to providing the best for his daughter. Her bad intentions were noticed and did not go unnoticed. Take your karma and stop harming people. Until next time.